Yes, there we go. Thank you.
The host had muted me. Sorry. So what I was saying was what I think is really interesting about the non-competes discussion that we're having currently is that it really builds on work that's been going on over the last decade or more, focusing on application of promoting competition in labor markets and how antitrust law has a role to play. So, for example, in the Obama administration, we started focusing on so-called no-poach agreements. These were agreements between companies, some of them were tech, some of them were others, not to recruit and hire other employees. And those were really important cases. The DOJ has continued to prosecute even criminally no-poach agreements between companies. And that gets the attention, obviously, of companies at every level, but also human resources directors and things like that. So it can be very impactful. And now we see the FTC focusing quite heavily, and DOJ a bit, but mostly the FTC, on non-compete agreements, non-compete clauses in contracts, and both enforcing under its Section 5 authority in standalone situations, but also engaging in a rulemaking for the first time. And so there, the real question is, okay, how broadly should the FTC be scoping a rule? Are there any exceptions that should be allowed for non-compete agreements in certain contracts, depending on the type of employee and the whether they're valid for protecting, IP or trade secrets or something like that. And what role do they play? And I think it's a really interesting moment in which to continue to try to evaluate those types of clauses and how they might be impacting both innovation and movement in labor markets, particularly when we are looking at highly skilled employees that may have specialized knowledge and training and abilities. I think the other thing we've seen the antitrust agencies do in the Biden administration, and this is also a feature of the Biden administration's executive order on competition, where there's discussion not only of non-competes, but promoting competition in labor markets, is to partner with the Department of Labor, but also to explore effects in labor markets in the merger context as well. And so that type of increased and expanded focus, I think, has really given the agencies a lot more information about the importance of competition in ensuring that people are able to move between different companies or start their own competitive options when they have the wherewithal interest in doing so. So I expect we're going to continue to see a lot of focus in this area, and we're still very much at the front end of understanding the pro-competitive benefits of it.
Yeah, please.
Just echoing a little bit of what Terrell was saying. I mean, there have been articles now for years. I remember being at the Department of Justice and seeing articles, 6 years ago, 8 years ago, about the proliferation of non-competes in the United States. And, my own 2 cents is that it has become a problem, but you see it, to my mind, the justification for non-competes are the least compelling when you're talking about blue-collar workers, minimum wage workers, who are less likely to be exposed to the competitively sensitive information or trade secrets of a company, and are nevertheless being hindered in their ability to switch jobs. So I certainly understand why the administration is focusing on that, and to my mind, the equities are most, and arguments are most compelling when you're thinking about that sector of the economy. Thinking about the tech sector, there are certainly situations where you have employees or executives who are exposed to competitively sensitive information or intellectual property and the like. Non-competes are not the only way to protect that. NDAs, other restrictive covenants. So there are a number of ways to, in a targeted and precise manner, try and, as an employer, protect your intellectual property, to protect your So to my mind, there's real value in the Biden administration's focus here, although to my mind, the value is really in thinking about how to peel these back in the sectors of the economy where they just aren't justified and they don't make sense.
So we have this idea that non-competes are necessary for executives or people who have sensitive information or special talents or help to build a company with particular unique valued expertise. And yet your question was, has this made California more innovative, that California doesn't enforce these? And presumably California is innovative because it has all these tech workers who have specialist information, specialist expertise, and they can leave. And so we have this kind of paradigm that non-competes are most justifiable where they find knowledge workers. And yet there's a way of looking at innovation which turns that on its head. So behind this paradigm, there's this kind of motivating idea that we need people to have the incentives to invest in building specific technology or companies, and incentives to hire executives, or incentives to invest in training them or developing particular know-how. And then they need to be able to protect that. So they need to be able to tell their workers they can't go take that information somewhere else. But you're all in law school, or most of you are anyway, and you come to law school to learn, and a lot of your learning comes from exchanging ideas with people freely, and that leads to new ideas. And so behind that, there's another paradigm of viewing how innovation works, which is kind of a sharing of ideas and pushing know-how out of places that have it into places that don't have it. And so maybe what competition law needs to do is actually tell, try and push the knowledge workers with very specific know-how, try and get them out of those places and get them into new places where they can mix their know-how with other people's know-how. And again, we don't really have the data to kind of say that protecting, tying these knowledge workers with non-competes will promote more innovation. But what we can say is that argument proceeds from a very kind of limited worldview that only sees innovation happening along one pathway.
Great, thank you. Abby, as more research is surfacing about the allegedly harmful effects of social media, particularly on young people, will social media companies become the new enemy of state attorneys general, as happened with the tobacco companies in the 80s and 90s?
I might comment on this one. That was the way.
That was a sign that you're not supposed to talk about this.
The FTC has an ongoing action. I'm sure most people in this room know, and our adversaries at Kellogg Hansen are here as well, against Meta in the Section 2 case in the DDC. I can't say whether can't really talk about the case or even say that's like an agenda to go after the social media companies. I think actually thinking the social media companies, maybe to Kathy's point earlier, is a little bit too myopic. It's backward focused in a way. We need to think about technologies moving forward, where things are going. That was certainly an aspect of the Meta within case of VR. A lot of people think that's the future. And how can we prevent what's happened maybe in social media from occurring when these new technologies are moving forward like VR?
Yeah, this gets back a little to the point I was making before, and one of the reasons why I'm not a big fan of legislation that targets a handful of companies that happen to be powerful today. I think we've been reasonably well served by the antitrust laws as they exist. They're imperfect. There are maybe some ways that they could modestly be improved, but the reality is industries change over time, and it's better to arrive at a set of principles that can be sustained and applied over time and be applied to a broad set of industries. So, to my mind, again, getting back to this point, I do worry a little bit about the amount of focus that's being placed on a handful of companies.
Got it. One of the things things that interest me about your background is your background in telecom, as I understand it. And we've talked about, of course, antitrust enforcement. We've talked about non-competes. I want to actually return to this issue of labor, because you brought up the blue collar versus white collar. But before then, I'm curious what you think about telecom policy as a way of because telecom, some of the big tech companies, you think of the voice over IP, you think of the Skype, the personal communication services, and they've sort of been able to skirt along without much in the way of telecom regulation, which goes back a century. But now we're seeing a change in policy. For example, in the EU, they recently revised their electronic communications code to bring in more of these over-the-top communications. And I guess I wonder if you have any thoughts about whether telecom policy could become a new vector to regulate some of these tech firms.
I'll answer that question, but where I thought you might be going with this, I'll answer my question first and then get to yours. I worked earlier in my career, I worked at the Federal Communications Commission for a couple of years, and it was the heydays of the FCC in the early 2000s. The 1996 Act had been passed, which introduced this idea of like, there's going to be competition in wireline telephone service. And a whole crop of, there was a very regulatory framework, and there were a whole crop of CLECs, competitive local exchange carriers that cropped up. They were in there competing with the various incumbent regional carriers across the country. And what I witnessed both on the outside before going to the FCC, but then on the inside, was that this very highly precise regulatory regime that was supposed to allow access to these competitive carriers, forced access to the incumbents' infrastructure, that system didn't work very well because you could technically comply if you're an incumbent, but make it very hard for your competitor, and it just, in the aggregate, became a death by 1,000 cuts exercise, and slowly over time, the CLECs mostly died out because the regime didn't work. And that's something that I've actually spent a lot of time thinking about over the last couple of years. I think there are some people that would like to regulate the big tech companies, today's big tech companies, in the same way. And I guess I have reservations based on my experience in the earlier days in the telecom environment that these access regimes, where you have incumbent firms that have to open up their network to competitors, it's a very hard regulatory regime to navigate and to enforce.
Yeah, and just to piggyback on that, I think there's been a spate of scholarship trying to see if there are any learnings from the 96 Telecommunications Act. You have articles like protocols, not platforms, where the idea is how do we handle the problem of bigness, if indeed that is a problem in big tech? Well, we're going to require compatibility. We're going to require data portability. We're going to require access to APIs and things of that sort. The question is whether that's really translatable in a far more complex technology space than phone wires, not to denigrate the publicly switched telephone network, but it is a simpler interface. And so I'm curious, really, this is for anybody, whether you think that might have legs, this sort of forced compatibility and interoperability.
I'm happy to jump in on this one. And
please, thank you.
Kathy, it's great that you're pointing to your longtime expertise in this area. I think that there are differences between interoperability and portability. And if you think about the evolution in the communication space, we see some of those differences playing out differently as well in terms of their success. One of the areas that I end up focusing quite heavily on in these important debates is also the conflict that starts to arise between privacy, security, consumer protection, and things like interoperability and use of data for different purposes, and regimes that then want to direct data to flow different directions, and you run afoul then of some of the other obligations around it. And that has proved to be a very, very difficult area in terms of really trying to land on true interoperability and even solving some of the portability questions, especially in, for example, platform spaces, social network type of companies where you're dealing with a lot of different forms of data.
Yeah, thank you for that.
Yeah, I'm just like candidly, I'm not sure, and it'd be great to put out there for the group. I'm not sure I've seen a total solution to that yet, although we've definitely seen attempts at organization around it.
Yeah, and it does seem to be an emerging area that still is under theorized. So it'll be really interesting to see if we can get to a place where it can be a really viable path to solve some of our tech issues. Going back a little bit to antitrust, Abby, when it comes to technology and antitrust, we're almost always talking about big tech firms, but mergers also happen between smaller firms, and including smaller firms that are direct competitors in a concentrated market. I'm reminded of the origin story of PayPal, where Peter Thiel's Confinity merged with Elon Musk's X.com to form PayPal, and at the time, these may have been two of the only firms that are really viable in the online payment space. But they were so small, the market was so nascent, it just didn't really capture much attention, and probably still doesn't today. Should we be giving any thought to smaller firm mergers in nonetheless concentrated markets?
I think so it depends on whether you're looking at that on the front end or the back end, because a lot of these, we were talking earlier about
Your other phone's switched off. Yeah, they're all off. I got 3 of them now. It might have to do, I can juggle them too. It might have to do with the computer, I'm not sure. Maybe we mute it while we're not. Let's try it now.
I think that's what, it was on, so let's see if that does it.
Yeah, let's see if that helps.
I mean, I think a lot of the issues are actually with what's reportable underneath the HSR. A lot of these smaller acquisitions of startups, don't make it. I'll just yell. Don't make it to us to review in the first instance if we can't compare them after the fact. And so I think that's a big hurdle. I don't think the agencies are purposely not looking at smaller acquisitions, even though that is obviously a huge company, but then was not. It was above the HSR reportable guidelines, so we challenged that. I think that's why certain these small, you'll see a lot of startups or a lot of challenges to startups because it's not reportable. It's under the $200 billion whatever the amount is, and that's why we don't see those. So we want to see more of them. Congress raised that in what, 2000?
Is it what, 101 million now? Is it?
That was 200, and then like 50 or.
No, I don't know.
Yes, I shouldn't misspeak either. I'm not the investigator. It comes to me when they decide to bring a complaint. But I think that's a big issue here is a lot of these acquisitions are just not reportable.
So when I was at DOJ, there were a few transactions that were not reportable that we did challenge. I think a hard thing there is, again, it's not coming to you. So if you're at one of the agencies, the way that you typically learn about it is somebody comes and complains about a deal that's already happened or is about to happen. And so you're left in the position, as Abby said, of challenging after the fact. DOJ has prevailed on facts like that. I think the hard thing now, I suspect, for Abby and her colleagues is that there's so much enforcement happening. Going back a year and a half, there was record deal flow. Some of those litigations are still playing out. Obviously, the big litigations against the tech companies and a very ambitious agenda from both the FTC and the DOJ. And frankly, and I hope the folks on the Hill are listening, like the agencies need more money. They need more money and they need more people because the good folks at both agencies are working super duper hard. And when you're chasing a number of these bigger ticket deals or monopolization cases, it can be hard to carve out the bandwidth to focus on these smaller deals, which over time might become important, but just it's a triage question.
Yeah, I'll follow up on that. This gets back to this idea of restrictive merger policy. We don't have the resources to be truly restrictive in the sense that it's going to affect whether startups are innovating or not. I really don't think we have that right now. The FTC is 1,100 employees. The Bureau of Competition is much smaller than that. We have in the litigation group here at the FTC, we have 8 lawyers, only 4 of them are first-year trial lawyers. I had a PI in December, I have one in July, an actual full-blown merits trial in July. There'll be more coming at the end of the year. We just can't challenge everything. There are a lot of anti-competitive deals that make it through because we don't have the resources, even in a very aggressive, what some people think is a very aggressive approach by both agencies right now. There's still a lot that's not getting done.
So we have a question. Someone wrote in, I'll just read this, particularly in markets they don't understand, courts seem fearful of false positives. Are the agencies disadvantaged when they're bringing challenges that rely on concepts like data innovation, virtual reality, etc.? This is obviously a broad question. I'll open it up to really anyone who has thoughts on this.
I'm happy to talk about it. Somebody doesn't want me talking here today. You know, having tried the MetaWithin challenge in December, I think courts, it's not just the technology, it's nascent industries. Courts are very reluctant to mess with things that they don't think they understand or they want to play out. And the way we approach it, I think this is right, is there's a lot of old law that the agencies are dusting off now. And courts are going to be much more, at least in my one experience back in December, with that, more receptive to latching on to principles that are grounded in case law. It's old case law. A lot of people didn't think it was good case law anymore. That was the subject of motion to dismiss, actually. But we could dust off those principles, give them to a very smart judge on the Northern District of California and say, look, it's not a big step to take these old principles and apply them here and take it in bite-sized pieces. The problem is how far do the bite-sized pieces actually get us without help from Congress, without the guidelines? Because there's only so much, the tools we have, I don't think necessarily get us all the way to proper enforcement these days.
Just dovetailing on what Abby was saying, you know, it was my experience at DOJ that when you have 2 firms that are established competitors in a concentrated market, and you have a history of them competing against each other, and that competition resulting in lower prices or better quality or more innovation, it's very easy for a generalist judge to understand what's at stake and to decide in favor of the government. But when you're talking about a nascent competition fact pattern, you know, an acquisition of startup that maybe isn't even commercial yet, you know, as a general matter, these merger cases, I think, are different from most of what judges do. A lot of what judges do is they look at conduct that's happened in the past and they decide has it violated the law or not. It's a crystal ball exercise that we're asking them to do, which is just as a general proposition, I think, different from the norm for most judges. And then when you add on top of that, that one of the 2 companies isn't in the market yet, or is just barely in the market yet, and you don't really know like what the competitive significance is going to be, you can just see sometimes the judges struggle with, is it a substantial lessening of competition? Because that's the statute, that's the standard. Section 7 of the Clayton Act prevents mergers that result in a substantial lessening of competition, and I think judges sort of struggle more with that in those fact patterns. But I also think that's an area of focus right now, and I know when I was at DOJ, we brought a couple of cases with those fact patterns. I know they are continuing to focus on those sorts of cases and to build out the law, so it'll be interesting to see.
Just jumping in on that. So, you know, when you have that situation that we're familiar with 2 big companies and they're used to stealing each other's customers, we kind of, you know, judges are familiar with it because the mental model is clear that, you know, they're trying to produce a better product or lower prices by stealing each other's customers, and you can kind of see it in the history. My reading, I'm not in one of the agencies, but my reading of the agency's recent cases has been they try and write them like these kind of detective whodunits where, you know, you have like there's a clear bad guy and history of, you bring up all these facts and you look at the executive emails saying this company's stealing our customers, and well, like, we can't outcompete them here, and so we're going to buy them, whatever. And so we're kind of filling in, in a space where we don't have a good mental model for like nascent competitors. We're kind of filling in our paradigm of how competition should work. We're filling it in with this like narrative that's rich in detail because that'll convince a judge. And I think I think that's good, but I think that what we need to develop is we need to develop some paradigm that we feel comfortable in of how competition works in these nascent industries or spaces. And so one that I would suggest is modularization is a pretty good principle, where if you think about innovation, it's kind of like an exercise in generating new knowledge. And innovation happens because you combine different bits of knowledge from different places. And so what you want to do is you want to take the kind of essential knowledge element of a particular innovation and then modularize it in a way that lots of people can access it. And so I suggest that this is like a good paradigm that, whether it's a component or an API or something that lots of people can tap into at the same time, that's a good kind of principle for newly developing nascent innovations that aren't quite there yet.
Just jumping on something that you said, I do think it's really important. I'm sure Abby, as a lead trial lawyer at FTC, thinks about this. It is absolutely a storytelling operation when you're bringing this to court. And even though under the statute, the Section 7 of the Clayton Act, which is the statute that the agencies generally use when they go in to try and block a merger, it's not an element to show that the purpose of the deal is to take out a competitive threat. In these nascent fact patterns that are inherently a little more speculative, in my experience, one of the ways that you overcome that kind of speculative aspect is if you can pull from the acquiring side's firm documents that make that intent very real. So I actually, in preparing for today, was looking back at a complaint that the DOJ filed in a case involving Visa's acquisition of Plaid. Visa obviously is a prominent company in the online debit space, and Plaid at the time was a technology upstart that was looking to make inroads into Visa's segment of the market. And when DOJ looked at the deal documents, there was this great graphic, and you probably won't all be able to see, but it was a picture of a volcano. And so the people working on the deal, the tip of the iceberg here was what was visible of Plaid at the time of the deal, but they realized that the technology that Plaid was sitting on had this enormous potential that was, below the surface of the water, a subsea volcano. And that picture helped to really, I think, illustrate what the whole transaction was about. That deal went to litigation. Obviously, there's a complaint. It ultimately abandoned, but it's just to say this is an example of what Ketan was talking about, that I think when you go into court, especially in these nascent fact patterns, I think the agencies tend to want to put together a story. And even though intent to take out a competitor is not an element of the charge, as it were, it is helpful, particularly in that sort of fact pattern.
Yeah, if I don't know if I'm muted or not. Maybe not. Okay. If I could just jump in, I think you're absolutely right. Happy to point out the important role of qualitative evidence when we're looking at potential competition cases. And I guess I would just say that, I do think that we have a framework that, while I agree judges may struggle with it, already exists and that can be pursued for potential and nascent competition cases. And in fact, if you think about it, although the FTC lost the meta within challenge, the court nevertheless accepted that actual potential competition or perceived potential competition can be a viable theory under Section 7. So Yes, are they difficult cases? We brought a case when I was an FTC commissioner challenging a merger between Steris and Synergy that we litigated and ultimately lost, again, because the judge struggled with what was the right level of evidence to show the potential competition. But so they're hard, but I think they are viable cases, and I expect we're going to continue to see agencies examining these theories and pursuing them, especially when, as Kathy points out, there's good qualitative evidence in the record that supports them.
Did you want to say anything?
I was gonna comment. Even your microphone is mad at me. No, I just yell.
Okay.
So in a potential competition case, it's, we're not talking about necessarily taking out your competitors, not competitors yet. It's almost like a reverse killer acquisition. And we had the opposite, at least our strategy in the Meta trial, was to not paint Meta as evil or their company, they're not city or good or whatever. We wanted to show that the world would be better if Meta itself was innovating and bringing these products to market, as well as having other people bring their products to market. And who else in this world who could bring a product to market that would change the world? The Mark Zuckerberg. There's no reason, that was our argument at least, why this very, very talented genius could not innovate himself. And isn't it better for the world for him to be innovating than simply buying companies? So that was one way we used qualitative evidence, and not to show an evil intent. I don't think there was one necessarily, but to say, look, these big tech companies aren't necessarily bad. They have a lot of, they've found great ideas. Well, innovate yourself.
So I think we're at time. Thanks so much to all the panel participants. Thanks, Terrell, for joining us, despite your other commitments. George or other folks from the Virginia Law and Business Review, not sure if you want to have any closing comments here.
Very brief.
Okay.
Let's see.
Okay, no, good. Yeah, I would really like to thank our panelists and moderators, everybody who came in from out of town. Thank you to the few who stayed till the very end here, and I'd particularly like to thank our symposium committee who have worked for months on this. It's just been great to see it come together, and great to be here with you all today.